Yes.
So, are you aware that 90% of cases in courts are plea bargaining and don't result in juvenile detention centers?
Okay, that still requires cost, hiring prosecutors on the state level. There are still costs incurred, that's still time, and that's still time that's taken from the judicial process, which has to be devoted to working out these plea bargains. I think we're underestimating how long it takes for a plea bargain to actually unwind. Now, I have a question for you. Given the nature of the internet, being that it takes away all subtleties that you get from human context, such as facial gestures, the tone with which an insult is delivered, how can you effectively prove intent in cyberbullying?
You can prove intent by how we define cyberbullying as persistent torment. There is intent if someone has done it multiple times, and that's what cyberbullying is. Therefore, if they persistently targeted, tormented, and harassed a person, you know there's some form of intent to harm the person.
Okay, but also, are you aware of the Megan Myers bill?
Yes.
Are you aware that it failed?
Yes, we are.
Okay, so are you aware that one of the reasons it was not sustainable was because they could not effectively define cyberbullying? It didn't have a rigid legal definition.
Well, first of all, the Megan Myers case was an example of cyber stalking, not cyberbullying, which is different because it's interaction between a child and an adult, not child and child.
But is that, okay, thank you. Do you have a question?
Yes. You mentioned the Drinking Act, and you said after they created it, the amount of drinking went up, am I correct?
Yes, from 1984 to 1993.
How can you compare drinking and cyberbullying when cyberbullying has an obvious intent to harm a person, whereas drinking is more of a self-fulfilled thing and not as much to outwardly harm another person?
Well, you're right in one case, but you're also forgetting the fact that cyberbullies are sort of a separate type of person. Psychologically, they are motivated to inflict harm, which is, obviously a different case from drinking. But that would mean that even more so, national legislation wouldn't work. Drinking is less radical of an act as cyberbullying, and that's merely to show the fact that, which is something that you haven't addressed yet, is that this could create a forbidden fruit complex, whereby kids think that it's socially acceptable or somehow cool to cyberbully or publicly bully other people.
But don't you agree that when there are consequences, people will be mindful and be less apt to do the forbidden acts under cyberbullying and commit cyberbullying if they know the consequences in criminal court?
Do people still drink? I mean, drinking isn't illegal. Underage drinking is illegal. People still drink. I have a question for you. On September 24th, 2010, Eric Holder was quoted as saying that the federal justice system is stressed to the breaking point. Now, all right, thank you.
The thing is that this doesn't actually make any sense in
concerns to this resolve. They're saying that it would create a forbidden fruit complex and that people would go and cyberbully because it's against the law. Murdering people is against the law, and people don't go out and do that for fun. It doesn't make sense at all. Now, drinking also, people do that for fun. Cyberbullying is not something that you go and do for fun exactly. Someone in cyberbullying is being hurt. It's not exactly the same thing as going out and having a drink with your friends. Now, they've said that this is going to be a felony, and that many people are going to be thrown in jail, and it's just going to end up being awful, and it's going to cost the country tons and tons of money. But we have defined, the resolve says that cyberbullying should be a criminal offense. They seem to be forgetting that there are 3 units of criminal offense: felony, misdemeanor, and regulatory offense. Now, felony means that you're putting in jail for over a year. Misdemeanor is fines, and you can be put in jail for under a year. But what we're really looking at today is regulatory offense, and basically you just have to do what the judge tells you. There have been fines in the past that can force you to go to counseling or something along those lines. If you are seriously hurting someone, then maybe you should go to a juvenile detention center. But if what you're doing is not that bad, then you might just get a regulatory offense, and you have to go to counseling or you have to go talk to someone. And then also they've said that this is going to cost a lot of money, and a lot of this cost for money would come from trial costs. And as we have told you today, from the Pacific Legal Foundation tells us that 90% of cases end in plea bargaining. So all trial costs would be moot in that point. And just because something is expensive doesn't mean that we shouldn't do it. And obviously we're in a recession and money is going to be tight, but if someone is being hurt, someone's being tormented and harassed, our opponents are saying, well, if it costs too much, then we just shouldn't protect these people. Okay. And now also, they brought up the Megan Meyer case and said it failed because people could not get an effective, they couldn't figure out a name for cyberbullying, couldn't really get a definition. I would also like to bring up that the Megan Meyer case failed because the Megan Meyer case demanded that all cases become felonies, and people in the House did not like that. They said that if all cases became felonies, then we'd be incarcerating millions of teens, and that's why it did not pass. But in our resolution, we're saying that it would not just be a felony, there's also misdemeanor and regulatory offense. And with that, I end